Hi everybody, welcome back to Law, Politics, and Society. This week we're going to be talking about juvenile justice, so let's get started. Juvenile delinquency falls under the umbrella of civil law. And so the term delinquent is actually Latin for to leave undone. And this reflects the rehabilitative nature of the perceived delinquency of children. That is, that they could be rehabilitated or they could be fixed or changed. And so juveniles historically have been subject to laws that make certain behaviors illegal for them that are actually legal for adults. And these are what we call status offenses. The status offenses apply to only juveniles that are considered violations of criminal law. So they can be things like smoking or drinking alcohol or having sex before the age of consent or being truant from school. These are all things that are not criminally punishable in the adult sphere, but are criminally punishable for children. And so this constitutes the largest proportion of juvenile offenses, these status offenses. And often this requires some jurisdictional challenges. Children can be controlled by what are called CHINs. They are children in need of supervision, where the state and social services agencies will sort of take guardianship of children, or PINs, persons in need of supervision. So this designates the difference between offenses committed by children and offenses committed by adults. So just how pervasive is juvenile delinquency? Well, the public image of juvenile delinquency is often fueled by sensational media accounts of very rare or atypical cases. So an example of this would be the Slender Man stabbings, where you have two girls ages 12 who attempt to sacrifice their friend, Peyton, or Bella, as she's called, in order to please Slender Man. That is extremely rare. But, on the other hand, juveniles do commit a disproportionate percentage of the FBI's Uniform Crime Report Part 1 index crimes, which are violent and property crimes. In fact, youth under the age of 18 accounted for 16% of violent crimes in 2009, despite being only 6% of the American population. Now, this might lead you to believe that there's something very wrong with American youth, but really, it's really hard being youth or a teenager. Shakespeare talked about this in A Winter's Tale, talking about how children between the ages of 10 and 23 should be temporarily put to sleep because they're just fighting, all the time fighting. They're fighting their hormones, they're fighting themselves, they're fighting all of these things that they don't understand or don't control. And individuals who don't engage in some form of antisocial behavior between the ages of 10 and 21 are actually pretty rare. Most of us engaged in behavior that we certainly weren't proud of between that age. We just might not have gotten caught. And in the New York Academy of Sciences conference on juvenile delinquency in 2003, there were really three key messages that came out of their understanding of juvenile behavior. The first is that a lot of the behavior that is common in adolescence is rooted in biology intermingling with environmental influences. And this causes teens to conflict with their parents. They're more apt to take risks. They experience wide mood swings, and they don't have the same sort of level of impulse control. They also have a lack of synchrony between their physically mature bodies. Their bodies are becoming stronger. They're more physically capable, but a still maturing nervous system. Your brain does not fully develop until you're 25. And so there's some imbalances there between what your body can do and what your brain has processed. In addition, adolescent sensitivities to rewards appear to be different than adults. So they're pleasure-seeking much more frequently. They're trying to achieve that high of an adrenaline rush, all of those endorphins that adults don't need to the same extent. So some developmental factors that we want to talk about. Puberty is what marks the onset of the transition from childhood to adulthood. And this is where neurotransmitters start to increase and the inhibitory transmitters decrease. So your inhibitions are lessened. You're more adventurous. You're more apt to take risks. Your brain starts to actually change. It goes under an actual physical reorganization, whereby the cells begin to mature and things start to change. And this is where you are more likely to commit criminal activity, is in this adolescence age. And in context of the justice philosophy, the best treatment is simply growing older. We have something called the life crime curve, where the older you get, the less likely you are to commit criminal offenses. And so this has been reaffirmed numerous times. And literally, the best thing that we can do is just try and get them to a point where they can appreciate the consequences of their actions, and help them get to a point where they can successfully age out of crime. Historically, youth have been considered property of their fathers, and the idea of not assigning full criminal culpability to young children is relatively new. So under the common law, if you were 7 or older, you would be prosecuted the same way an adult would have been prosecuted for the same offense. So obviously, the jurisdictions varied a little bit. Some were 10, some were 7, but this is a drastically different understanding of the level of criminal culpability than we have now. And it's partially because in the early common law, they didn't appreciate the extent to which the brains of children were different from the brains of adults. Currently, in most states now, you'll have a range. Some states it's 10, some states it's 12. It can depend on the jurisdiction. Historically, in early Rome, you had children considered to be the property of their father, and were under the control of their fatherly power or fatherly love. And this became sort of prominent to restrict the power. And this started to happen in the 4th century. There was a trend towards limiting the power fathers had, culturally and over their children, but there was still no different legal system. Within the Middle Ages, you start to have a shift to lessening of the brutal nature of treatment more generally. Children under 7 finally were held to be not responsible for their criminality. And then there was a special status that was created for children between the ages of 7 and 14. But 14 was considered the age cutoff for different treatment, as that was the age that you were marriable. And so if you could get married, the belief was then you had full appreciation and consequences of your actions. The big change was in the 13th century after the passage of the Magna Carta, and the courts adopted the Latin phrase parens patriae. And this gave the king the control over the children. So parens patriae, the father of the country, allowed the state, not the parents, to have authority over their children. So the state could reprimand or control children by enforcing laws and creating punishments. Now, in the United States, delinquent British youth were frequently sent to the colonies as indentured servants. So these were typically 4-year sentences. If you if you were completely of good behavior the entire time, it could be 4 years. Typically, it was longer, and some individuals never paid off their debts. And these individuals were similar to slaves. They were considered legal property of their owners. And in this sphere, juveniles were frequently arrested and placed in jails or prisons with their adult counterparts. And in the 1800s, you had a huge economic downturn, which caused a lot of limited opportunity, which caused a lack of support. There wasn't enough food. It was akin to a sort of mini Great Depression. And then you had the Civil War. And so this caused vagrancy and begging to increase. People didn't have enough. They didn't have enough food. They didn't have enough opportunity. They didn't have places to stay. And they would often be incarcerated with adults. And it was during this time that the Society for the Prevention of Pauperism, which was later renamed as the Society for the Reformation of Juvenile Delinquents, was formed. And so we see this transformation begin to recognize that this was bad for society, to have these poor children and to be locking them up with adults and not giving them opportunities and instead criminalizing them, because it was recognized that the primary causes of this criminality were economic. So if you gave children food and shelter and training, they would no longer be susceptible to criminality. The New York House of Refuge was the first juvenile detention sort of facility. It was originally created to house orphans, but eventually started to house juvenile offenders as well. And the children would remain there until it was determined that they had been reformed. But the criteria for what constituted reformation was often very arbitrary. So it was really up to the wardens of the New York House of Refuge to determine if you had been rehabilitated enough. And this could take a very long time. Parents could also voluntarily place their children there for offenses such as being idle or refusing to work and being disorderly. So this could be, talking back, refusing to obey, very small things that could lead parents to essentially forfeit the rights to their children. In 1838, we see a legal shift for ex parte Kraus. And this is in recognition of what was called the Child Savers Movement. And so this recognized that it wasn't about what was easiest for the parents, but it was about what was in the best interest of the child. How can we support the best interest of the child? And so the purpose of the House of Refuge began to train and care for children. But it was very similar to Bridewell's. It was very focused on discipline. And often children in these places were exploited and they were working long hours. Frequently, they were mistreated in these places. So even though there was a change in focus, we didn't see the change in result until a little bit later on. So the Child Savers movement was really middle class, and it was this discontent with government corruption and inefficiency. How can we have these poor, starving children when the government, you have these elites at the top who have a lot of money and economic excess? And so progressives fought for the professionalization of the public service, making sure that it wasn't just cronyism and getting in based on who you knew. And there was an ideological attack on the House of Refuge because there was an argument that juveniles could be molded into better citizens through compassion and care and not constantly being berated and having to engage in forced labor. So one of the things that they did was they placed children in farms in the Western United States. But it depends. Like, some of them really believed in the goodness of children. Some of them really didn't. Some believed that poor children were innately criminal and that being poor was a sign of a personal defect, some sort of flaw in the person. And so they sent them out west to avoid them coming back east and causing a problem. And so there were really mixed messages coming out of the Child Savers movement. The beginning of the juvenile court system starts in Cook County, Illinois, so not far from Madison, in 1899. And by 1945, the end of World War II, every state had its own juvenile court. And so initially, the courts used the civil law standards, which was the preponderance of the evidence standard, 50.01%, more likely than not that the individual committed the offense. And judges were given wide latitude, both in sentencing and in guilt finding. Typically, there were no juries here. There were just judge trials. And there were different terms used within the juvenile system than there were in the adult system. And that was designed deliberately to reflect that the goal of the juvenile system was really rehabilitative. The purpose was not to incarcerate and remove them from society forever, but to improve them into better children. So here's a slide of the different terminology that is often used. We don't say arrested in the juvenile system. It's typically taken into custody. We don't talk about whether or not an individual has pled. Instead, we say they've admitted or denied responsibility. Instead of a jury trial, they have an adjudication hearing. So very different language, largely because it's born out of the civil system. Similarly, frequently the incarceration would be called juvenile detention. Prison could be called training school, and parole would be referred to as aftercare. So there really were many differences in terminology. But not all children stay in the juvenile system. So under certain circumstances, juveniles can be transferred to adult court, and this causes them to lose their status as minors. So this means they will be legally culpable for the alleged crime. And once they've been transferred into adult court, you can't go back. You can't have one case adjudicated and then other cases adjudicated in the juvenile system. It moves you fully into the adult criminal system. The age at which this happens depends on the state. Sometimes you have to be older than 15, some states 17, so it can depend. About 1.5% of juvenile cases are waived or transferred to adult criminal court, so it is pretty rare. But there are three primary ways that this can happen. The first is through a judicial waiver. So in this process, a judge makes a discretionary decision based on a full inquiry. So 48 states allow for the judicial waiver. Some have a mandatory waiver if certain criteria are met, and some have a presumptive waiver where, based on the nature and severity of the crime, it will be assumed it will be moved to criminal court unless you can satisfy criteria showing that it should not be. The two other mechanisms for a juvenile waiver are the prosecutorial discretion or direct file process. And this is where prosecutors can choose whether or not juveniles should be tried in juvenile or adult court. And 14 states and the District of Columbia allow for this type, so the prosecutor has sole discretion. The third is statutory exclusion or a legislative waiver. So this varies from state to state, but what can happen is that state legislatures can say that, for example, murder cases cannot be tried in juvenile courts for those over 16. They have to go to adult court. And 31 states have this type of legislation that just creates a firm rule. And some states prefer this because then you don't have the prosecutorial discretion picking and choosing. You just have a firm and consistent decision. But one of the things that has happened is that shifting juveniles into adult court has not given the presumed social benefits that people assumed would come out of it. And it also doesn't guarantee a more punitive disposition. Just because it gets moved to adult court doesn't mean there's going to be a guilty finding. It doesn't mean that there's necessarily going to be a long incarceration. So often the reasons for moving something to adult court have not really been satisfied. Okay, what about the role of due process? Well, critics have argued that the parents patriae doctrine allowed too much latitude for courts to restrict the rights of juveniles. And it was argued that the similarities to the adult correction practice made it more inherently punitive. And so there was an argument that juveniles should be afforded the same due process protections as adults coming through the U.S. Constitution. And the courts really didn't make a decision one way or the other until Haley versus Ohio in 1948. And in Haley versus Ohio, the court held that the 14th Amendment prohibits police from violating the due process clause in obtaining confessions from juveniles. And it also maintained that illegal confessions were going to be inadmissible in court, regardless of whether they came from a juvenile or an adult. So they gave them more protections to avoid having their rights infringed. They also held that coercion was inappropriate in obtaining sentences from juveniles, or confessions from juveniles, pardon me. In Kent v. United States in 1966, we see a question of whether or not there should be some more oversight as it relates to the waiver system. So Morris Kent initially came to the District of Columbia's attention when he was 14 and charged with several burglaries. And several years later, he broke into a woman's apartment and stole her wallet and raped her. And the process by which he went before a judge in the District of Columbia and the process by which he was allowed to be waived into adult criminal court came under suspicion. And so the Supreme Court said juveniles have constitutional rights. There's no place in a system for trouncing all over rights, whether it's juveniles or adults, and that the waiver decision is a critically important process within the criminal justice system, and they have a right to have support at that point. In R v. Galt, in 1967, we get the 5 basic due process rights for adjudication hearings, or the trial portion of juvenile processes. You have to have the proper notification of charges. You have to have the opportunity to have legal counsel. You have to be able to confront witnesses against you if you want to. You get the privilege against self-incrimination, and you are allowed appellate review. So this is really making most of the constitutional provisions applicable to juveniles. And then we get a lot of case law. The sort of floodgates open. So in Re Winship in 1970, they said, no more of this just 50% standard. We need a beyond a reasonable doubt standard if incarceration is a possibility. So we can't use preponderance of the evidence if the juvenile is facing incarceration. In 1971 in McIver, juveniles do not have the right to a trial the same way that adults do. And this was sort of controversial. But it held that the jury trial was not going to be helpful for juveniles, that it was going to put a great strain on the court systems, and that there should be this adjudication hearing process by a judge. In Breed v. Jones, double jeopardy applies to both juvenile and adult courts. So if you lose in juvenile court, you can't decide you're going to try it in adult court or vice versa. So it limited the prosecution's ability to retry juveniles, which was a positive. In Shaw v. Martin, preventative detention is unconstitutional. So you can't detain children with a hunch or on a suspicion that they might do something, right? Some of you might have seen the movie Minority Report, where we start arresting people because we think they might become criminals. And the court said, no, we can't just hold them until we figure out whether or not we're going to have a hearing about something. Preventative detention is unconstitutional. And then recently we've had 2 really big decisions, Graham v. Florida in 2010, which said the imposition of life sentences without the possibility of parole for juveniles is unconstitutional unless it's for a murder sentence. So anything else, you cannot give a life sentence without a parole eligibility. And in Miller v. Alabama, they said that the mandatory life without parole system violates the 8th Amendment for cruel and unusual punishment for juveniles, and you cannot give mandatory life without parole. One of the biggest issues that has confronted juveniles has been the juvenile death penalty. And between 1973 and 2003, 22 juvenile offenders were executed in the United States, with 13 of those being in Texas. And this issue has been controversial since the 1980s, and there's been 4 Supreme Court cases on it since 1982. So the first was Eddings v. Oklahoma, and this is where the court didn't ban the death penalty for juveniles, but said that the court must consider all mitigating factors before deciding whether or not to impose the death sentence. So were there any mitigating things? Did this individual grow up in poverty? Had they been previously victimized? Did they have any mental or cognitive impairments? What was their home structure like? You had to consider all of these things before imposing the death penalty. A few years later, in Thompson v. Oklahoma, the court said no death penalty for children under the age of 16. So they created a line that said, regardless of the offense type, children under 16 could not be executed. In Stanford the next year, the court held that it was constitutionally permissible to execute juveniles who committed their crimes at 16 or 17, but it did reaffirm the minimum age set in Thompson. So if you committed your crime at age 16, you could still be executed. It wasn't just if you were 16 or 17. Once it got to trial, you had to have committed it at 16 or 17. And then fairly recently in Roper v. Simmons, the court drew the new line at age 18. And they said anything before that violates the Eighth Amendment's prohibition on cruel and unusual punishment. So there would be no executions for children under the ages of 18 after 2005. The distinctions between the adult and juvenile court systems have started to become very blurry. And this is because the juvenile court system's proceedings has really started to mirror the procedures of adult courts. And juveniles have often been forced to give up some benefits in order to gain others. And we can see this example in Megan's Law. So Megan's Law requires adjudicated delinquent sex offenders, so child sex offenders, as well as convicted adult sex offenders, to have to register with law enforcement agencies for the rest of their lives. Now, that was controversial because, yes, it would be appropriate to put a 17-year-old who is adjudicated as a sex offender who has, committed sexual assault or sexual abuse, but sometimes indecency counts as a sexual offense. So what if a child is, you have a 12-year-old who's going around mooning people or indecently exposing himself, right? Is he a sex offender? Should he be on the registry for the rest of his life? That's a really tough balance. What should be the consideration there? How should that be determined? And so there's been some difficulties in navigating treating all children the same and treating all offenses the same, because they're certainly not. One of the key features in juvenile justice is the phenomenon of restorative justice. So restorative justice is the process by which there's an attempt to repair the harm that has been caused by the act. And this means typically a face-to-face confrontation or conversation between the victim and the perpetrator, where there's a mutually agreeable restorative solution. And this can only happen when the victim is willing and if the offender pleads guilty or is adjudicated delinquent. So this can help offenders be accountable and to repair the victim and the community and allow them to start to heal. So this is the first sort of victim-driven model, because all previous models were really sort of offender-driven. And one of the major innovations in this was based on a grant that was held by the government, the federal government, and the Office of Juvenile Justice and Delinquency Prevention really called for a change in the juvenile justice policies, new models based on philosophy of juvenile crime as a social problem, not an individual ill. And the result of this was a restorative justice framework built into juvenile corrections. And so this really appeals to help repair damage in the community. It can be very, very, very cathartic for victims. It can help victims feel supported and understood, and it allows for some accountability, which may lessen the overall sentence of the offender. They're typically very balanced approaches, and there are three equally important components for the sanctioning of juveniles. So you want to hold the juveniles accountable. You want to enforce that what they did was wrong. You also want to protect the community. And you want some competency development programs. You want to rehabilitate. So you want to ensure that in a period of confinement, the juveniles can get access to education. They can complete their GEDs. They can get anger management classes. They can learn life skills. And the VORPS process that was created, which stands for Victim Offender Reconciliation Programs, were very successful. You see 97% satisfaction among victims. And typically in the traditional process, you didn't see more than 25% victim satisfaction. So this is a huge increase. And the Office for this juvenile justice and delinquency prevention has really embraced this restorative justice approach. It's not meant to necessarily replace all traditional methods. It's, again, only when an individual victim is willing to participate and when the offender is willing to participate. So certainly not everybody is going to be participating in this process, but it can be a really healing and cathartic practice. It's hard to measure how well it works, really, because it depends on what your metrics are. If you're looking purely at reducing recidivism, restorative justice works best for low-risk offenders anyway, and they have a lower risk of reoffending more generally. So your recidivism metrics might not be the best mechanism, but in terms of remorsefulness, how empathetic people can be, assessing consequences, feeling satisfied with the justice system, victim satisfaction, all of those metrics really show that restorative justice can be incredibly beneficial. So I know that was a whirlwind walkthrough through the juvenile justice process. In your discussion questions, we're going to talk about the juvenile justice process in schools now that you've watched Cash for Kids, as well as the Slenderman case, which is a really interesting and novel case. And I hope you enjoy learning about that this week, and I will be speaking with you soon.